This program is brought to you by Emory University.
Okay, thank you. Good afternoon. Thank you all for coming and for this opportunity to discuss the structure of my dissertation. Special thank you to Professor Martha Feynman for her generosity and support and invitation to Emory. My dissertation title is An Approach to the Collective Dimension of Rights, and I have subtitled this presentation as Revisiting the Fundamental Contradiction of Rights Discourse from Individual to Collective Interests. In explaining the problem, first I would like to address that in public discourse, rights have become an hegemonic tool to explain social and individual problems in political, international sphere, such as human rights, but national context as fundamental rights in the continental view, or basic rights in the common law approach, common law systems. Also in the international landscapes, we have seen the regional systems of human rights emerging, the European, the African, and the Latin American, and the inter-American systems of human rights. So, and in particular, within Latin American constitutionalism, rights talk is particularly important, especially when, in relation to what has been called the new Latin American constitutionalism, that is characterized by these detailed and long lists of rights. So it could seem that human and fundamental rights have won this ideological battle to its critics from the conservative and the most progressive sides of the spectrum, and they have proved this dynamic character that I would like to analyze. Of course, we have to start from the point that fundamental rights or basic rights are like this double sword institution, because when you address a rights discourse, you are not only like advancing the social or political rights to access to the public spheres, but you also are protecting property rights or freedom of contract, negative liberties. So, but of course, rights started from these negative liberties, but they have also served as a translation to the political culture of certain experiences, such as particular experiences of pain and of fear, and this characterization of rights has played an important role in the in Latin American context, especially because of the dictatorships. But what is the fundamental contradiction that I have addressed in this presentation is that in the beginning of the discourse of human rights, of fundamental rights and basic rights, it is the idea that we need the liberty, individual liberty, and a space for action, and that this liberty is unlimited and every restriction has to be specially justified. So we need this liberty to engage in actions and to engage in what we believe are like life paths, whatever, and we are the best situated to know which is the best life plan that we want to follow. But this, if in one hand we want this space to be more open, on the other side we want security, and if this space of action is open and is widened, it also, on the other side, it increases the chances of harm. So at the end, like, the fundamental contradiction of liberal thought is based on the idea of what we have been discussing of the liberal subject, of this idea of the independent, self-sufficient, unencumbered self, that poses the subject in contradiction not only to the state as the main threat to its liberty, but also to the social interest. From this idea, from this fundamental contradiction, the main conception of rights has emerged. And it's not like, for this is no surprise that the main idea of rights as trumps over the collective interest has so much strength. So rights works as a shield to protect these individual interests. And the other thing is that rights are confused usually with things, with the object of rights, rather than being understood as relations. But, of course, we know that rights are not absolute. From the constitutional theory, we encounter case law in which balancing here or proportionality on the continental legal structure is applied. And also, if you only take individual interests, some rights cannot be explained by themselves, like freedom of speech or the press. Because if we only take the individual interest into consideration, these rights, there are other rights that should deserve more heightened protection, such as housing or education, but free speech has gained this paradigmatic importance. And the other thing is that rights is the institution, what I call the institutional character of rights, and it's mainly like based on this quote that tells the dissenters and resistors in the East demand free speech and thought as the preliminary conditions for political action. The rebels in the West live under those conditions, where these preliminaries no longer open the channels for action, for the meaningful existence of freedom. And I quote, and I cite this because from this quotation we can understand that rights are not static devices, but rather they evolve in time, taking a dynamic character. And especially, for instance, in dictatorships, this idea of freedom of speech is particularly a pressing need, but like a negative right, like a shield to authority. But when you gain democracy, that same shield does not, prevents you from participating in the public sphere. So what I mean is that rights change, even they remain even when the codification doesn't change, their meaning to people, their meaning is different. So the best way to understand rights in a more comprehensive way, I would, or the proposition of the dissertation is to view them in a relational and dynamic character. This idea of rights, of course, is not very original, but it is developed from certain authors in jurisprudence, in legal theory, such as Joseph Raz, that has understood rights as these intermediate reasons that justify imposing duties to others, based on the special importance that not only individual but collective interests have. Instead of arguing that rights are only claims that mean imposing duties to others, I rather would say that rights in themselves are better understood as positions or legal relations. And for viewing that, I think that the better way of understanding them is through a three-stage analysis. And this has also been proposed by Robert Alexi. First, viewing the reasons that are behind rights, then understanding what are the positions or relations involved, and then their enforceability. In the reasoning, we can find the intellectual, the individual, and the collective interests. The positions or relations, here I have used the distinction that Hofeld made on legal rights. And why is the importance of Hofeld here is because it helps us in viewing that, one, rights involve relations in the correlatives to others. For example, the immunity involves a disability to the political sphere, but also it highlights the privileged nature of liberty. Here he talks in relation with rights as liberties, he names them as privilege. And I like that wording, even though it is not the most common wording used, because it highlights that the correlative to certain positions that are called liberties or privileges are on the other side, that the other part has no right to claim a harm, or better said, it is a permission for harming others, a privilege. And I think that is especially important from a vulnerability approach that would engage us in discussing or in unveiling the privileges and their rationality. Also, in the positions or relations, we have the power as the ability of the individual to change the legal positions of others. And also for me, it's important to understand rights from the power perspective because it could be a way of understanding rights as the access to a public sphere and to participate in the construction of the state's will. And finally, what Hofeld names as the central or the limited versions of rights are as claims that involve a correlative duty. This way of understanding rights allow us also to view them as an evolving institutional structure that will change accordingly to the social structure or to the needs of the social structure. Not only rights are not just related to one duty, but they involve what it has been named as waves of duties, and in a creative dynamic, the same right can create further rights. And for this rather abstract presentation, I focus on free speech. But on the other hand, I would like also to understand how the collective interests work in rights discourse. First, you could say, what are the collective interests? Of course, those interests that whose benefits are for all the community, for all the society, and that are namely, or what we could name as national security, public order, public health, public morality. All these collective interests or public goods are understood as a limitation on rights, as an external, involving this fundamental contradiction between individual and collective interests. So they are in conflict. But you have not only public goods, such as the ones that I have mentioned. Of course, public goods, they have been developed by the economic theory as these non-excludable or non-rivalrous goods, as these goods that whose consumption cannot be divided and it is not possible to prevent people, consumers who have not paid for it, for having access to them, or my personal consumption does not diminishes the consumption of the other people. But from these public goods also, we have what has been named as the collective goods. This is a type of public good where not only the consumption but the production cannot be done individually. It has to be, are collective in nature, such as public and open culture. But I would say also, because a typical public good in economic theory is the light of the lighthouse for the ships. And also is named the vaccination or public health, but I think that vaccination and public health would enter into the category of collective goods since we need participation to produce the positive effect. These collective interests work as limitations, but also within the three-stage analysis of rights in the reasoning. And I apply to free speech. Why free speech? Because it's a paradigmatic civil and political right, not only in the US. Its defense has been described as a characteristic of the national identity, but within the Inter-American Court of Human Rights or system, it is a foundation for democracy. However, free speech involves certain contradictions within itself because it is a problem it can become a problem to democracy or a puzzle to liberalism because from free speech, of course, it can be dangerous, enable or incite crime, undermine the same democratic system that wants to support, and encourage in general separation rather than unity. So it is especially a powerful right, and because it's also an individual right to view how the collective interest plays in free speech discourse. Here I put, typically free speech is understood through the values of toleration as a civil right, then participation as a political right, but there is a question mark whether we can understand free speech from the solidarity's value. Then there are two dimensions to free speech. One is the individual, like the street corner speaker, this idea that you only need to engage in free speech your voice, and that the streets are open to all. So, but this view that has pervaded in the US legal landscape presupposes this autonomous, self-sufficient, independent individual. But it also presupposes that there is dissent, and that dissent can be freely expressed. Because of this idea, the social imaginary that comes within this street corner speaker is the free market ideal that is the modern free speech model of the US. But this this idea of the free market or the market of of free ideas is deft, or this paradigm obscures the limitations that market has to provide public goods. It is not a problem of the from the scope of the market, but its capacity to provide the goods that are supposed to do as information or broadcasting, or to ensure the diversity rather than having the silencing effects. And well, it has this idea of individual as the street corner speaker, but it also has a collective side that is the right of the society to gain information, and taking into account both dimensions, you have the right of communication. Then you get a collective dimension of free speech in the subject of rights when you consider society being the right of society of being informed, a collective right, but you also have a collective dimension in the object of free speech, the broadcasting or the information as public goods. And third, you got also in reasoning about the right of free speech, collective interests. Especially when you take into consideration the democratic or the collective self-government reasoning, like free speech as a foundation for the political system that requires not only that one can express freely or criticize government in a way of accountability, but also the creation of the open and robust public debate. And this is a collective good because it requires, it's like the duty of the citizenry to participate, like the greatest menace to freedom is an inert people, as Brandeis stated. Then, well, I refer to the models, how to regulate speech, and you have like three social imaginaries: the state regulation, and the market regulation, or the public sphere model of free speech, that it should be the ideal, that involves three main areas of communication: with public actors, private, and the communitarian that has been developed in the Inter-American system. And then I apply this to the Inter-American system of human rights. The Inter-American system of human rights is particularly regulates speech in the convention, in the Inter-American Convention of Human Rights, in Article 13. What is characteristic of this regulation is the prohibition of prior censorship, however, with the exception of public entertainment to protect childhood and adolescence, only subject to subsequent impositions of liability, and that it has recognized that the expression can be that the expression can be violated not only by the abuse of government but also because of private control. That's very interesting in developing this right. So also it has recognized the dual dimension, the individual and the collective right, as individual and a collective right, because of the right of the society to be duly informed, and especially has developed in the reasoning of the court, this idea of democracy and public debate. However, within the models of the regulation of freedom of expression, within a democratic reasoning, it is evolving from an immunity right to a power right. Like, instead of being a shield, engaging in the development of the right of access to the public sphere. The problem that now we encounter is the administratization of speech, and of course that would lead us to questioning the state and the typical liberal suspicion of state power in the new regulation of media. Finished. Questions, ideas?
So I want to talk about your idea about the evolution of rights, and how you envision that process. Okay, so I think it was a very interesting talk. Thank you for that. But it seems to me that the problem with rights as a framework is that the evolution is controlled by what powerful interests control society and its institutions. And I think the whole idea of rights based on the individual sort of model, since that is the focus of the rights discourse, is that the power gets hidden. So everything is susceptible to the kind of social power that I'm talking about, economic and other kinds of power that I'm talking about. But not everything is as untransparent, it seems to me, as rights discourse, which locates things within the individual. And so even though things are evolving on a social level, the social dimension, the political powerful dimension, is for the most part hidden. And I would, in addition to your analysis of free speech, although I think you can see it there too with cases like Citizens United in the United States, so that what happens is that corporations become persons and money becomes speech. Mm-hmm. And that really just destroys, or has potential to destroy, the functioning of our democracy. But I would also like to see an analysis of the Second Amendment and the right to bear arms in the United States in that context again, because I think that when you start to look at those, at the way those rights have evolved, both the negative evolution of speech and the negative evolution of the Second Amendment rights, rights to bear arms, that you see some of the problem with using an individualistic rights-based model when what you really want to talk about are how we can establish collective good. So why not start with the collective rather than the individual?
Yeah. Well, one of the things that I view as the institutional character of rights, and this idea that they should evolve or they should change, is that rights, or the discourse of rights, is very linked to authority. I think that when they emerged, or when rights were born in the 18th century, against a monarchy or against like the divine authority, you could understand that rights were shields, or the individual side of rights, or imposing this type of and the equality that they addressed. But now the power has changed, and so do these institutions should change, like because at the end also rights involve transferring power. They are powers. They are a type of power. So the meaning of this power changes. Of course, the meaning of rights in the U.S. is highly controversial. As you said, corporations have rights, even though the whole idea of human rights is dignity and like the person who the embodiment may be. And you have translated this to corporations, maybe because it is based on a liberal subject that reflects the corporation. So in that sense, like the vulnerability analysis could help could help like changing the discourse of rights rather than leaving them aside, or not aside, but for instance, in starting from collective interests, instead of separating the idea of collective interests as something that opposes individual rights, engaging into a discussion within the discourse of rights, but in their reasoning. And I think that is more appealing to even the US discourse.
But the problem with that, let's just take Citizens United. So the right to free speech, which a corporation now has, but even independent of that, the corporation always had a right to property.
Yeah.
And what happens with free speech, of course, is that the right to free speech collides with the right to property and to control property. So in the context of broadcasting, and I noticed on the, although you went too fast for me to write it all down, but on the inter-American system, they talk about this rights of free speech, and they talk about that the state or private interests don't have the right to abuse the access to broadcasting and other kinds of systems for dissemination of speech, right? But there's interesting questions there. What constitutes abuse? Right, and what it seemed that they were talking about was actually government or private control over technology. So that would be something like what just happened with the net neutrality, perhaps, although we'll see how that turns out. But it seems to me that that's very different question. I can't go and demand that the New York Times or the Wall Street Journal or CBS or even whatever they are, Fox News, allow me to have free speech on using their technology, because that's when it hits with private property. And there's no way that the state can regulate that access, but provide that I have that access under a rights model, because it's these two rights in conflict, and that they're just resolved. The property right trumps in that context the free speech right in any meaningful way. So rights, to a large extent, are merely formal, as long as you don't care, or not you personally, but as long as the system does not take seriously your third thing, which is the enforcement of the rights, the realization of the rights, and so they tend to be just this formal, individualistic, almost symbolic concession. And it's true that they may evolve, but what they do to really change, again, the fundamental power dynamics in a society, I still can't see that.
Well, in relation to free speech, I understand that now sometimes even the idea of free speech has collided with property. Like both, you can distinguish them, because when you try to regulate speech, it is not only free speech as the First Amendment, but also property rights that are involved, and they seem also even more powerful to prevent an intervention. But in the US, you have the interesting doctrine, the Fairness Doctrine. I understand that it's the Fairness Doctrine that was I know that it is now unconstitutional, but it was a famous case, Red Lion. It is in the tradition of free speech also to understand that you have to provide both sides of the story at the end. That
Fairness Doctrine.
Yeah. So that's another way of understanding free speech that also, even in the U.S., has got its minute in history.
Paula, thank you for your presentation, and I apologize for coming in late, so I know I missed the very first comments you made, so forgive me if my question is something you had addressed already. I actually find it quite fascinating, all these sort of relations like rights as relations, rights as immunity, rights as power. It seems almost like rights is the foundation of everything. It seems like everything can sort of be defined as rights. Things like power and immunity, I've never really thought of them in the context of as rights, okay? But rather, if you have power, then you may have the capacity to concede rights to those that don't have that power. So it's let's say rights as privilege. I'm finding it very broad, and so I guess my question is, what is the promise of rights if they can be translated or related in all these different dimensions? And what would you say is the promise of rights as well?
From my perspective,
Yes.
from my perspective, or my idea is, I don't know, like the discourse of rights started as a very revolutionary one. Of course, it has developed to something rather conservative in one side. And what I tried to explain at the beginning, it was that it is a double-sword institution because it was born revolutionary, it has developed to a rather conservative discourse sometimes, but on other times it has been quite liberating. In Latin America, the whole idea within at the end of the 20th century with dictatorships, the discourse of rights was powerful to oppose state power. But in particular, within free speech, and I would like to put it in a context so you understand what I think the promise of rights should be, would be to evolve from the immunity idea of rights as negative liberties, because that is structured in the idea of the liberal subject. The problem with that idea is that it is a conservative one. It is if you conceive rights as immunities, you don't change. You have your corner, you have your space, and if you are the liberal subject, great. But if you are not, you are in problem. So instead of this idea of immunity rights, understanding them as power. And there I have to acknowledge that my understanding of Huffold is, I need more understanding of Huffold, because I think in the concept of power, I differ with what he understands as power. Because for me, power should be like I like the idea of power as changing positions, but for me it should be the rights should provide the capacity to act with others for change, something like that. And free speech should serve that purpose, not to isolate us or not to exclude others, but rather serve as understanding bridges between communities.
So what do you think about, thank you so much for those useful comments. What do you think about the reality where rights are actually limited and rights don't exist until they have formal recognition? Formal recognition either by the state, or if we're looking internationally, when we look at international human rights, there's just actually a limited number of rights that are recognized to exist. And so what do you think of that sort of limited conception of rights and how that may mesh with sort of the promise of rights?
I think that's why it's so important their institutional character. I think they are institutions that evolve accordingly to the social structure. It's difficult to understand them, or it's difficult to understand the universality of rights, because that's one of the promises of the rights discourse, that they are universal as uniformity. Of course, they are not uniform. So it depends.
So then, I'm sorry, I don't want to dominate. I think you wanted to say something. No, just my very last comment was just also the role that scholars play in sort of defining rights or arguing that certain rights are not yet well defined enough to be accepted. You know, that's, you know, what's your take as a scholar in terms of?
Well, I think I think that ideas are powerful, and even when they can take a while to be like or to gain recognition, and it's a continuing battle, I think. And sometimes you need to gain more strength and to gain consensus, for gaining the consensus and for reaching the ones that at the end apply. You are sort of you have power, but a different kind of power. But of course, it is an important role, a limited one also. But it is how culture works, and how, yes, that would say.
I'm sorry also for being late. Maybe I missed some the presentation, but thank you very much. My question may be related to the discussion in here, but I'm thinking about this in terms of if we have rights that actually in conflict with each other. Like, what do you think about, you know, if the state or the one with the power here to give these rights should put these rights in order, so one of them comes first, and then if the second in conflict with the first, then we have to go with the respective first one, you know. And I can see this argument maybe in free speech, and in the same time when it comes to the conflict with the freedom of religion, for example. Like, you can express your feeling about a specific religion, and at the same time you give another individual the right to freedom of religion. So how do you think if these two rights come in conflict, what do you suggest something to avoid this conflict somehow?
No, I think that the conflict, of course, is inevitable, and you decide case by case, and well, proportionality, the idea of deciding, I don't know if weighting the rights is a correct representation of what judges do, but analyzing the measurements against the public interests would be, is done. Yeah, it's done as a way of resolving conflicts within rights, analyzing which public interests is in place, and yeah, the benefits and the harms.
Thank you for your presentation. I found it fascinating. I have a question. You spoke during Adriana's comment. You had something to say about the universal value of rights and how rights cannot be uniform. So recently, I have been reading some work on by authors who say that because rights are products of their social and historical construct in some sense, and when you place them in context with the law fixes meanings and reifies identities and constructions. And so social justice movements need to go beyond the law and the rights discourse, and look at other subversive sides to help those movements gain rights. And I was wondering if you had explored some of these questions through your work, and what your comments would be on this.
I think that's a powerful critique, the idea of refining rights, and I would say that I cannot deny that there are the ways, and of course, rights is not the the solution and the only path for like social problems or social contestation. But is the tool, I think, that the legal system provides to all of us, with its own limitations.
So, just thinking about your dissertation, right? I mean, is it possible to think about your project as explaining the very important role of rights, both as mobilizing opposition to existing power structures, and also as initial forays into correcting those, and at ways to kind of challenge that, the revolutionary potential that you talked about. But also recognize that part of the evolutionary process is that evolution might lead to obsolescence, or you've kind of fulfilled what was possible, all the potentiality of rights, with some minor exceptions, has actually been realized now in terms of confronting entrenched power interests and other kinds of inequalities, kind of like the history of formal equality, and where you can realize formal equality, but then you look around and you see that really didn't change anything fundamentally, right?
Mm-hmm.
So that we're now at a point where we have to start thinking maybe not of rights, but something else, like maybe interests or needs or some other way of thinking about it. And then how is it that we build a discourse around those things rather than rights, again, are conclusory. They're totally dependent on recognition by the state or some formal, body. And again, the conclusion hides the power dynamics, all of these things like interests and needs that really, I think, underlie the idea of conception of rights. So, how do we make that discussion more transparent, not just the conclusion, this is a right, but, the argument about why it should be given priority or recognized. So, when I listen to your dissertation, which again, I really admire and like, and so that's not, but I just want to push you to think about not ending with the concept of evolution and the concept of allocation of power and privilege, but thinking critically about this question of have rights, which would it be? Have rights. Reached their, realized their potential, and now, while as formal equality is one person, one vote, great. Equal pay for equal work, great. But that does not solve the major maldistributions of power, economic power, wealth, and so forth and so on, social goods in society. We need another discourse to do that.
Mm-hmm. Mm. Yes, it could be like a second thesis, a second dissertation.
Or the concluding chapter in this one.
Thank you. Yes, probably. I will think about it.
Okay. We can talk about it some more too.
Yeah. Thanks. Well, thank you. Thank you for the questions and the discussion.
Are there other questions? Well, thank you.